All right, good morning, everybody. Welcome to a virtual oral argument session of the Fifth District Court of Appeal. Today's a very special day on which we look back to June 6th of 1944, which was D-Day, and recall the sacrifices made by all the Americans to help free Europe and to maintain freedom throughout the world. So we want to always keep that in mind. And with that having been said, I'm Judge Edwards. I'll be presiding. With me are Judge Boatwright and Judge McIver. As you can see from the names on the Hollywood Squares thing we have here, there's a clock. You will have 20 minutes each side. Typically, we reserve 5 minutes for the appellant's rebuttal. If you want something different, just say so, and we will make those arrangements. The color's not always obvious on the computer screens. Green means you have all your full time, yellow means you're into your rebuttal, and red means stop. 20 minutes is your full time. There's no extra time for rebuttal. We have one case this morning, and that's case 23-2506, Richard Davis versus Dawn Davis. And Ms. Perry, you may commence when you're ready.
Thank you, Your Honor. May it please the court, my name is Allison Perry, and I, along with John Napoleano, represent the appellant, the former husband, Richard Davis. I'd like to reserve 5 minutes for rebuttal. This case involves an order of contempt, finding the former husband in contempt for failure to pay half of his adult child's college tuition, pursuant to the parties' marital settlement agreement. The husband argues first that this contempt is improper because you cannot enforce a contract to pay adult child's college expenses through a contempt action. That's the Nicolodi case, and that's cited to in my brief, which also cites to a fifth DCA case of Southard v. Southard, which is 756 Southern 2nd 251, which also holds it. You cannot enforce a contract for payment of an adult child's college expenses through a contempt action. So that's the first argument the husband makes. The second argument the husband makes is that no reasonable judge or person would have found that the agreement required him to pay 50% of college expenses since secondary education. It required him to pay secondary education, which means high school. There's no dispute that secondary education and secondary institution means high school. There was no dispute at trial regarding that issue. So finding someone in contempt for something that's not clear and concise for them to follow is error. The third argument the husband makes is the court effectively rewrote the contract when it substituted college for secondary education, and found that the parties intended for him to pay for a college education instead of high school education. So those are the three arguments made by the husband. Are there any questions?
What about the phrase, should one of the children not attend a secondary educational institution? How does that make sense in the context of that provision?
Well, they could choose not to attend a regular high school and go to a vocational school, which would still require him to pay a portion of his portion of the vocational school, or maybe even a private school tuition.
When you read that, why would a child, am I reading that correctly, that why would a child in Florida not attend a secondary institution? Is that the way you read that?
Yes, Your Honor. Okay. So a child could not attend high school. Children drop out of high school all the time and then re-enroll into high school. So, and there was a cap of 21 for the financial obligation to end at the age of 21 if they chose not to attend a secondary school, which undisputably means high school. And once parties, the trial court is prohibited from inserting different definitions into contracts when the parties have chosen the language. The parties are free to contract, and they chose this language. It meant high school, not college. And I think there's no dispute that if the words would have been high school in there, that there would not be this lawsuit. So the language is clear. Secondary institution means high school. You substitute those words in there, and it's a clear contract anyway, but it makes it even clearer when you just put in the words high school.
Counselor, if the child had chosen to go to a private high school, could the former wife have used paragraph 10 to force the former husband to pay half of those private high school tuition expenses?
Yes, Your Honor. That's exactly, yeah, vocational school, private school, technical school, anything that would have had a tuition.
Okay. Let me ask you this. You've made a claim on behalf of former husband for attorney's fees. Is that correct?
Yes, Your Honor.
And what is the basis of that?
The basis of that is in the agreement, the marital settlement agreement. It states, in the event that either party fails or refuses to comply with the provisions of this agreement, the failing party shall reimburse the other party for all losses and expenses, including but not limited to attorney fees and all costs incurred as a result of such failure. And that is at R214 of the record.
Right. That's paragraph 19. That provides fees if one party has to go to court to enforce it and is successful with enforcing it, correct?
Yes, Your Honor. Yes, Your Honor.
And your client is not suing to enforce the agreement, correct?
Correct. He's defending against it.
Okay, paragraph 19 does not literally or explicitly provide attorney's fees for the party successfully defending against a suit to enforce the contract, does it?
That can be an interpretation of that paragraph. Yes, Your Honor.
I'm asking you literally and explicitly. Yes. Does it say that?
It does not say that it allows for defending.
Okay. Is there another basis then for fees that you've requested, or is that it, paragraph 19?
No, Your Honor, that was it.
Okay. All right. I don't know if my colleagues have other questions or not.
So if this was for college expenses, if it was actually for college expenses, can the court enforce this through contempt?
No, Your Honor, it's a civil action. And that's...
So by a civil judgment, is that how it would have to be enforced?
Yes, Your Honor. Either the child could sue, or if the mother had paid, then the mother could sue. And that's the Nickelodeon case and the Southard case out of your district. Are there any other questions?
Any other questions? Doesn't look like it right now. So you have almost 13 minutes for rebuttal. So we will turn the floor over now to Miss, is it Scarano?
That is correct, Your Honor, Scarano.
Okay. You may proceed when you're ready.
Thank you. May it please the court. My name is Kimberly Scarano, and I represent the former wife and the appellee in this case, Dawn Davis. As the court is aware, the entirety of this appeal and this issue centers around paragraph 10, essentially, of the parties' marital settlement agreement regarding secondary school expenses, as it's titled, and consists of two separate sentences. The first sentence being that, excuse me, the parties agree that the husband will be responsible above and beyond the standard monthly child support for 50% of any secondary educational tuition and or related expenses. And that should one of the children not attend a secondary educational institution prior to the age of 1, then the husband would be relieved of this responsibility. The first issue that the appellant has raised in his brief is that contractual obligations for college expenses are not enforceable by contempt. The first time that this was raised was on appeal. This was not an argument that was made by the former husband in any motions that he filed with the court, nor in any argument that he made at the actual contempt hearing that was held before the trial court. So we would state that this is a new issue, excuse me, that was raised on appeal and therefore should not be considered. However, moving forward with that, I know that opposing counsel has cited the Nicoletti case. The Nicoletti case in that particular situation as the basis characterized it solely as a contractual duty to pay for child college expenses. However, other cases, including the East v. League case, which I have cited in our brief, the courts have found that when the college funds and the college expenses are intended by the parties in the MSA as a child support provision, that it would be enforceable by contempt. And if we look at the terms of this particular marital settlement agreement, the language is clearly intended to be by the parties part of child support. It specifically says that he shall be responsible above and beyond the standard monthly child support for 50% of any of these additional fees. And it's our argument that under the cases such as East v. League, that this would allow the court to find him in contempt and to find that this provision is enforceable by contempt, not purely just a civil enforcement, because of the fact that it was in the nature of support. Additionally,
Counsel, excuse me.
yes,
In the East case, the court said the party settlement agreement unambiguously indicated that the provisions for Children's College Fund was intended as child support. We don't have the agreement, so we don't know what that unambiguous term was, correct?
that would be correct, Your Honor.
And it's also really talking about paying into a college fund, which again, we're going outside the record, going outside the opinion, which often gets you into trouble, but it's not uncommon for children who are not 18 to have a college fund set up. So we really can't tell just from that opinion, can we?
From the opinion, correct, because we don't have the exact verbiage from the parties' marital settlement agreement in East v. League. My argument would be that if we look at the language in our case, however, that the court would still reasonably be able to find that it was intended to be part of support for the children. There was also testimony from the former wife at the hearing that when they came to this agreement, that it was in lieu of him paying a higher amount of child support while the child was a minor, would be in exchange for him to pay for this going forward.
But that extrinsic testimony is belied by the magistrate's report, which found that $400 was within 5% of the requirement, and former wife's own child support worksheet came up with an amount of about 413, 401, something like that. So again, without that extrinsic testimony, that doesn't, if we exclude that, there's nothing to show that it's for child support. Correct?
Only the language that's contained within their actual verbiage of their settlement agreement is that it would be above and beyond the standard monthly child support. And that it was also contained, paragraph 10 is also contained within the section of the MSA that addressed all of the child support and support related issues for the parties, including, if we look at that, paragraph 8 was specifically child support, 9 was for the health insurance and other insurance for the children. Paragraph 10 was this provision. How they were allocating childcare expenses was paragraph 11, and the dependency tax exemptions was paragraph 12. So if we were to look at that in the totality of the settlement agreement, it is also contained within specifically the support provisions of their agreement.
Counsel, I asked your opposing counsel, had the child gone to private high school, could former mother have used, I'm sorry, former wife, she's still the mother, I misspoke, former wife used paragraph 10 to force former husband to pay those private tuition expenses for high school. Would you agree that she could have used it for that purpose?
I don't agree, Your Honor, and that's because there's nothing in the text of the parties' marital settlement agreement that contemplated that the child was attending a private high school or private elementary school or private middle school.
Does it have to be in the marital settlement agreement, that contemplation?
I would think if we are looking at the court interpreting the language of paragraph 10, we have to look at both or not only what the parties included in the verbiage of their marital settlement agreement, but what they excluded. And the fact that they excluded any specific language that this would apply to private school should be given the same consideration as if they had included it. They did not include that as an anticipation.
Counsel, you agree that the literal meaning, the well-understood meaning of secondary school is high school, don't you?
I agree, and that's what the trial court found. And
there are high schools here in the state of Florida that charge tuition if you attend them, correct?
I agree with that, Your Honor.
Okay, so under this agreement, had the child chosen to attend a school, a high school that charged tuition under Section 10, wouldn't former husband have been responsible for 50% of the tuition expenses?
If we just had
Under the four corners of the document. If that occurred under paragraph 10, couldn't former husband and father be forced to pay half the expense?
I think our position is that the second sentence of paragraph 10, when read with paragraph 1, makes the definition of secondary education so that it's not simply high school. Because, and as the trial court found, it would be illogical that a child would elect not to attend a secondary school at an age that is, if we were to read secondary school as high school, approximately 14 years old.
You've made a couple of structural arguments about how we should interpret the settlement agreement based upon where the language is found. That language about his obligations being discharged, that clause is specifically talking about his obligations being discharged. So wouldn't there be an ambiguity there as well that would say that term means if the child chose not to incur costs by attending a secondary school, private or otherwise, that would actually cost money, that's when his obligations would be discharged. It's not necessarily you didn't choose to attend any secondary school, but you didn't incur any costs when you attended secondary school, so thus your obligations are discharged. Is that at least a reasonable interpretation of that language?
I believe that would be a child could have attended college on a full scholarship, and there would not have been any charges incurred. It could go both ways as to both applications.
My question was more about the ambiguity in the discharge clause as being able to apply to a secondary rather than a college.
I believe because
can you see a reasonable reading there, I guess is my question.
I guess I could see a reasonable reading there. However, if we were to again read those two clauses in their totality and in the context of the four corners of the document, I still believe, and it's our argument, that it would be unreasonable to believe that this would not apply to college because of the fact that it says, should one of the children not attend a secondary institution prior to the age of 21.
Again, my question was, if a reasonable reading of that is would not incur costs by attending a secondary institution prior to the age of 21, that obligation would be discharged. If that's a reasonable reading, and if that clause is essentially your hook for saying the first paragraph is ambiguous, I'm a little confused how we can go that far.
I guess I'm not arguing that the first paragraph is ambiguous, just that the second paragraph further defines the party's intent of what secondary education meant. That the parties were not intending secondary education to mean high school, because if you read it, and as the trial court found, if you read it in its conjunction, we would have to assume that a child by the age of approximately 14, when most children attend high school or commence high school, could elect not to attend a secondary school.
For us to look beyond the plain meaning of the term secondary school, doesn't there have to be some ambiguity in that clause?
I guess perhaps I think it's more of how the parties, we have to look, not necessarily that the clause in itself is ambiguous, but how the parties intended that phrase secondary school to be used based on the totality of their agreement.
But I mean, over and over and over and over again, courts repeat that the best indication of the intent of the parties is the words that were used in the contract.
Absolutely, Your
We're gonna
Honor.
look, and if we're gonna look beyond the plain meaning of those words, then there has to be some question about those plain meanings, i.e. an ambiguity about them. And if your hook for that ambiguity is your discharge clause, I'm troubled by the fact that there's another reasonable reading of the discharge clause. That's what I'm asking you to help walk me through.
Okay, I understand what you're saying. So again, yes, I believe that his obligation would have been discharged if there was no cost incurred prior to the child turning 21. However, that doesn't, whether a cost was incurred is not necessarily mean that the child would not have attended it. The child could still have attended college at 18 through 21. And again, as stated, there would have been, maybe it was full scholarship and there was no cost incurred. So therefore, he would not have had an obligation if there had been no cost incurred for the child to attend the secondary school or college up to or commencing at 21.
I keep hearing you say 13 or 14. Is there anywhere in this provision that mentions someone being 13 or 14?
It does not state that in this, Your Honor. I was referring to the findings of the trial court.
So someone could choose possibly not to attend a secondary institution prior to the age of 21, correct?
Under Florida law, I believe there would be some truancy issues if a child suddenly was not in school at the age of 13 or 14. And I don't believe there is any other separate statute or law that would allow a child to elect not to.
Children could go to secondary school up to the age of 21, correct?
That would be correct, Your Honor, yes.
So if a child was in private school at 18 or 19 and decided they didn't want to go anymore, that wouldn't fit within the context of the provision?
Under our argument would be, no, Your Honor, it would not fit within the context of this, that this was intended to be for the purposes of college.
Well, that kind of gets back to Judge McIver's question, then you're talking about having to bring in extrinsic evidence, and so then it's ambiguous, correct?
If the court had found that it was ambiguous, yes, it would have to bring it in extrinsic evidence. The trial court in this case did not find that that was ambiguous.
But it relies on the testimony. It relies on a lot of testimony in making the trial court in making its decision, correct? And extrinsic evidence?
No, Your Honor, I would disagree with that. If we look at the transcript from the hearing itself, the court had already essentially made its finding and heard all of the arguments regarding the legal argument of the term secondary school before it moved on to the portion of the hearing where it was asking for testimony as to the college expenses, because that was the subject of the contempt, obviously, was the amount of expenses that would have been owed.
If there's no ambiguity, counsel, how can the court consider anything other than the words written on the document? You said the judge found there was no ambiguity. How can the judge then look at anything other than the words on the document? And secondary school, everybody agrees in this case, is high school.
And I would agree with that, Your Honor. Unfortunately, in this particular circumstance, the judge did not clearly make a finding that something procedurally in the way that the hearing, I wasn't present at the hearing, progressed. There was not a specific step-by-step. I am therefore finding this. I am or am not allowing extrinsic evidence. It happened as.
Well, he did allow extrinsic evidence. There's no doubt about that over former husband's objection.
Well, when actually there was no objection by the former husband when the wife put on the testimony of their party's intent. In that particular part of the trial transcript, she was testifying as to the expenses. Questions were then asked as to what conversations the parties had. Leading to that, there was no objection by the former husband at that time.
Perhaps I'm mistaken. I thought the former husband thought there was an agreement that he had a standing objection, but if I'm mistaken about that, I will stand corrected, but I can perhaps anticipate appellant's counsel may be looking for that passage right now. So we may get some clarification on that.
And Your Honor, the former husband himself, when he testified, presented extrinsic evidence as to what he believed that meant at that time. So for the former husband to, on one hand, say, hey, we objected to any and all extrinsic evidence coming in. He didn't object when the former wife testified as to it, and then he put on his own testimony as to it.
Well, if the judge allows extrinsic evidence to come in, the former husband would be a fool not to offer what he could, correct?
I agree.
That's
I
not,
agree.
that's not a waiver. When the judge says it's coming in, that's not a waiver to then play by the rules that the judge says, is it?
I'm not, no, Your Honor, it's not a waiver. I'm just simply stating that when the former wife testified as to that, there was no objection made as by the former husband at that time, and then he did proceed to present some.
Ms. Carano, help me through one more problem that I think we might have here. If the term secondary school didn't mean the plain meaning of you're going to pay for high school, when the judge found that to mean college, take me beyond the idea that that's rewriting the contract. If it didn't mean high school and the judge decided that it did mean college when it doesn't say college, please tell me how we get there without that being a reformation of the contract.
Because there was no other logical meaning for what it meant other than it meant post-secondary after high school education. And because the court found that that was the logical, reasonable meaning of post-secondary education, it was an interpretation of the word post-secondary education as the parties intended within the four corners of the document, and not a new additional term to the parties' contract that he was adding to it.
Well, and I guess that's kind of the thrust of my question. Taking the word secondary and changing it to post-secondary, is that not changing the terms of the contract?
No, Your Honor, I don't believe that it would be. I believe it was the court's interpreting the contract, what the contract meant based upon the language of the agreement and its totality. And that to interpret it any other way would have been illogical, because as I have argued before and in my brief, that would essentially be giving a 14-year-old or like a child that would be at the age of going into high school the ability to say, I'm not going to go to school at that age.
Or
And
it would likewise give the child the ability to go to a private high school and make former husband pay for it, correct?
I apologize, Your Honor. Could you repeat your question? I didn't hear the very beginning of it.
Sure, no problem. Again, under paragraph 10, if the child had gone to a private high school, paragraph 10 could have been used to force former husband to pay the private high school tuition, correct?
I suppose that argument could be made. However,
I don't know how you can't make that when it says secondary school and he's responsible for half of it. I don't understand how you can avoid that.
well, if we are to look back to the language or the argument that was made by the former husband, both at the time of the hearing and currently, his argument was that secondary school was not private school, but would have been an additional vocational or other type of school. There was no distinction made or argument made by the husband that anybody interpreted this as public versus private school.
So fine, vocational school, any school where tuition or any kind of fees, say you're going to learn how to do woodworking, you have to pay $10 to buy your wood to work on, or you're going to, whatever it is, if there's any fee or expense under paragraph 10, the former husband would have been on the hook for half of it, wouldn't he?
He would. Again, this is assuming that we're talking about a vocational school is something that a child could even enter before completing standard high school.
There's nothing in the record one way or the other, is there?
That is correct, Your Honor.
Have you made a claim for fees on behalf of the former wife?
We have, Your Honor.
And on what basis specifically?
On the paragraph contained within the MSA regarding the fact that either party, if they have to enforce the terms and provisions of the agreement, that they would be entitled to compensation for attorney's fees.
Okay, and you agree that the literal reading of paragraph 19 is the party suing to enforce, which would be your client, must be successful in the enforcement, correct?
Correct.
Okay, all right, I think your time has expired. Do colleagues have any other questions for appellee? Okay, then we're back to you, Ms. Perry.
Thank you, Your Honor. First, I'd like to address the standing objection to parole evidence. And that can be found in the supplemental record at 505 and 532 of the supplemental record on appeal. So over her former husband's counsel's standing objection, parole evidence regarding the meaning of the MSA context was permitted, even though the former husband's counsel argued the terms of the MSA were complete and unambiguous. So that's that record site. Also, the fact that the trial counsel did not bring up the fact that contempt was not the proper proper avenue to pursue this enforcement of this contract of this adult child's education. That has to do with subject matter jurisdiction, and subject matter jurisdiction can be brought up at any time, including first time on appeal. The judge was correct in stating that after the marital settlement agreement was reached, the wife filed her child support guideline worksheets pursuant to the parties' incomes. The husband's child support obligation was $401.12. That's at 132 and 134 of the record on appeal. And also the report and recommendation of December 2008 found that the child support was within 5% of the guidelines. That's at 150 of the record on appeal. But like I said, the court has rewritten, the trial court rewrote this contract. Secondary education means high school, and putting post in front of it changes it dramatically, and that you just can't do that in Florida. So I ask that the court reverse.
Ms. Perry, are you familiar with the cases that discuss the fact that providing college education or paying tuition and college expenses for adult children is indeed a moral obligation of parents who can afford to do so?
Yeah, it's a moral obligation, but not a legal obligation.
Colleagues have questions?
Yes, sir.
Okay, thank you, Your Honor.
All right, thank you. We'll be in recess then.